Okay. We did a cell phone extraction, a forensic cell phone extraction on Paulina's phone. I did subpoenas to verify the Amazon package delivery. We did. I did interviews at the Mexican restaurant to verify Mr. Boilou's account given to me during his interviews.
So let's kind of, and like I said, I want to take those things into specific terms. So let's talk about that phone extraction first. Were you the actual person who did the extraction on the phone?
I did not do the extraction.
Who did the extraction on the phone?
Karen Patterson.
Okay. But once she does that extraction, are you the one who actually then goes through and looks at the contents of the phone?
Correct.
Did you have an opportunity to look through Paulina Wright's cell phone, full extraction of her phone?
Yes, sir. Was
there anything in her phone that, let's just kind of put it this way, assisted you in your investigation of the case? There
was a photograph of her and Dale at the Mexican restaurant that was flagged in the cell phone extraction. Outside of that, there wasn't anything evidentiary added to it.
And to confirm, that photo that you saw of them at the Mexican restaurant was at the same day that this incident occurred?
Yes, sir.
Okay. But other than that photo, there was nothing else that provided any other additional information towards your investigation one way or the other?
No, sir.
Okay. Now, you also talked about doing a subpoena to Amazon. What was the purpose of doing a subpoena to Amazon?
To verify Mr. Boilou's account of the Amazon packages arriving with his gun cleaning supplies.
And with that request to Amazon, did you ever receive anything back from them?
I received a response back from them.
What was the response from them?
That they could not locate a record.
Does that mean that the package did not come, or just that they did not necessarily have enough information with what you provided?
That they didn't have enough information.
Okay. Does whether or not the Amazon package arrived on that day or a different day, would that have changed or altered your investigation at all?
No, sir.
The last thing I want to talk about is you mentioned that you also followed up and you went to the restaurant that was mentioned during the interview. You yourself went to the restaurant?
Yes, sir.
Okay. Were you able to essentially receive any sort of documentation or proof that the defendant and Paulina Wright were at the restaurant that evening?
Not conclusive that they were actually there.
Can you kind of explain what that means by not conclusive?
So I have a receipt from the restaurant that outlines 6 total margaritas that were purchased during the time frame that Mr. Boilou said that he was there. However, there's no identifying information to actually positively identify that that was Mr. Boilou's table.
So just to confirm, there was nothing on the receipt indicating that Mr. Boilou or Ms. Wright were the ones who purchased those.
Correct.
However, it was somewhat consistent with what Mr. Boilou said was consumed at the restaurant.
Correct.
Okay. And was it during that general time frame as well that the defendant provided you?
Yes, sir.
What about, was the neighborhood canvassed for potential other witnesses or other videos that would have maybe captured the incident?
Yes, sir.
Was there any other witnesses that were discovered that would have provided any additional information?
No, sir.
Sorry, excuse me. What about any surveillance videos?
No, sir.
It also came up during the interview, and we've kind of heard it throughout the trial, but I kind of want to talk to you for a second about it. You ultimately determined or knew that the defendant was at the time employed by law enforcement.
Yes, sir.
What agency was he employed with?
Marion County Sheriff's Office.
Okay. So I want to ask you this. I know you work for the Ocala Police Department. Was there ever a point in time that you've ever worked for the Marion County Sheriff's Office?
Yes, sir.
When was that?
2010 to 2018.
What capacity did you work at the Marion County Sheriff's Office? What was your job title or position there?
I was in the jail as a detention deputy at the time.
Okay. And were you also able to did you have the duties and training to also be a on-the-road officer as well?
I had the certificate to be a law enforcement officer as well.
But you were just located primarily in the jail?
Yes, sir.
Did you work with or have any knowledge of Leslie Boilou when you were working with Marion County Sheriff's Office?
Yes.
Okay. I want to briefly ask you, to be a law enforcement officer, whether it's with Marion County Sheriff's Office or the Ocala Police Department, do you have to undergo any sort of training or anything of that nature?
Yes.
Can you kind of briefly describe to us what are some of the basic trainings that you guys have to go through or essentially do to become a law enforcement officer?
Every year we have what's called our in-service training, where we go through several topics, again, throughout a year, one of which being firearms, driving, first aid, defensive tactics, just to name a few.
And just to confirm, I made sure I heard that correctly, is one of the things that you have to do annually as a law enforcement officer is training on firearms.
Correct.
Your Honor, I have no further questions at this time.
Cross-examination?
Please, the court, yes. Good afternoon.
How are you, sir?
I'm good. How are you?
Good.
All right. And Sergeant Kirk,
Yes, sir.
your first contact with Mr. Boyley that night was at the police station.
Yes, sir.
Do you know how long he had been at the police station before you spoke with him?
I couldn't give you a direct time or an exact time, I should say.
But you spoke with him twice.
I did.
And then after your second conversation, you came in an hour and a half later, took photos of him, took his clothes, and told him he was under arrest.
Sure. Yeah. I mean, and in that time period after the second interview is when those events occurred. Yes, sir.
Okay. Do you know how long your first conversation was with him?
I can't give you a time frame. I would say roughly 30-ish minutes or so.
About 16 minutes and 13 seconds. From the time you walked through the door to the time you walked out the door. That sound right?
It sounds about right. Yes, sir.
Well, that's what was on the video.
Okay.
Do you know how long your second conversation was?
I can't give you an exact time, no, sir.
11 minutes and 13 seconds. That sound right?
Sounds about right.
Do you know how long he spent in the interview room before you arrested him?
I would say several hours.
Over 8 hours. That sound right?
Sounds about right. Yes, sir.
Because he got to the interview room at midnight, right?
I didn't take him there, sir. So I don't know what time he actually arrived there.
As the lead detective, are you responsible for checking the information provided by the deputies or the other officers, everybody involved in the case?
Yes, sir.
Do you know who brought him to the police station?
Patrol brought him to the interview room.
Do you know which patrol officers?
No, sir, I don't.
So Officer Hagan Sampson testified earlier that he and his partner, Officer LeBay, transported him to the police department at midnight.
Okay.
So do you know how long he was in the interview room before you first spoke with him?
I don't. No, sir.
Would it shock you to know it was more than an hour?
No, sir.
Do you have any idea what he was doing in the interview room before you spoke to him?
No, sir.
You ever watched the tapes of him in that interview?
I've watched the interview room video. Yes, sir.
Not while you were in there.
No.
During the 8 hours you weren't in there.
Yes,
Did you ever watch the video of what Mr. Boyley was doing in the interview room, especially during the first hour?
I've watched the video several times, sir.
So what was he doing in the interview?
He's been sitting in the interview room waiting for me to come there eventually.
That's all he was doing, sitting?
Sitting there. He was showing some emotion in there at some point.
Well,
But-
he was crying,
Yes, sir.
screaming, right?
Yes, sir.
End up on the floor. That went on for the entire hour before you ever saw it, right?
Yes, sir.
So you came in the third time with the evidence officer, took photos, took his clothes, put him in a jail jumpsuit, and then another officer came in and put handcuffs and shackles on him. And he sat in the room with handcuffs and shackles on him for the better part of an hour. Right?
Yes, sir.
You knew him.
Yeah, I knew of him. Yes, sir.
Well, you knew him because you used to work in the jail
Yes, sir.
and you saw him almost every day.
I would not say I saw him every day.
I said almost every day.
Okay. But yes, sir. I
You
know.
knew who he was.
I do.
You know he goes by Dale and
Yes, sir.
not Leslie.
Yes, sir.
Did you tell your superiors that you knew him before you went in there to interview him?
Yes, sir.
Was that calculated?
No.
Was it appropriate for you, knowing him, to interview him under these circumstances?
I don't think it was inappropriate.
Did you give any consideration to having somebody else talk to him that didn't know him?
I was the lead detective in major crimes at that time, sir. So it was my case.
Right at the beginning of the first interview, you told him you didn't know anything about guns. Was that true?
Partially.
How? Explain partially to me.
The Daniel defense thing, I couldn't tell you what that was when he told me what that was. Go ahead.
Well, you had firearms training when you worked for the sheriff.
Yes, sir.
You have firearms training while you work for OPD.
Yes, sir.
Have you been trained to use an M4 or an AR style rifle?
I have personally shot a AR style rifle that are issued to the Ocala Police Department officers. However, I do not have one assigned to me.
Okay. But you've trained them.
Briefly. Yes, sir.
Well, they teach you how to take them apart, put them back together,
Yes, sir.
and how to make sure once you put them back together, they'll go bang when you pull the trigger, right?
Yes, sir.
And that's important, that you put it back together right.
Yes, sir.
So what you told him wasn't exactly true. You just didn't know what the Daniel defense thing was.
No, like I said, it was partially true.
He mentioned in his statement resetting the trigger. Did you know what that meant?
Yes, the resetting the trigger pull. Yes, sir.
Tell me what that is.
If you pull the trigger of a firearm, you can feel a trigger reset on that. It's kind of hard to explain without actually feeling it for yourself, but you will feel the trigger reset on that. In this case, he would have had to have put the bolt forward on the second trigger reset which would then chamber around into the rifle.
Well, isn't that part of the process of resetting a trigger on an AR style rifle?
Again, I'm not issued a rifle. I have very limited training with the rifle.
So did you ask him what he meant by reset a trigger?
Yes, I did in my interview. Yes, sir.
Did you have him describe exactly what he did
Yes, sir.
to reset the trigger?
Yes, he said he pulled the trigger.
Okay.
And I asked him several times to clarify his statement while I was in the interview with him.
All right. He told you it was an accident, right?
Yes, sir.
And he told you they'd been having a good evening.
Yes, sir.
No disputes. You didn't ask him about earlier in the day, did you?
No, sir.
Do you know how long the two of them had been together that day?
As in how long they were together that entire day?
That day, yes, sir.
No, sir.
That wasn't relevant to you, what had gone on between the two of them that day?
No, sir.
Why not?
That had nothing to do with what happened hours beforehand. What happened was at that residence, and that was what I was investigating.
He told you they'd been to dinner that evening, right?
Yes, sir.
And he told you they had 3 drinks each, margaritas.
Yes, sir.
And you went to the restaurant and you found a receipt for somebody that ordered 2 meals and then 6 margaritas.
Yes,
right?
sir. Yep. Yes, sir.
What time was the tab open on the receipt?
Roughly 1930.
Okay, so that's 7:30.
Yes, sir.
And what time did it close?
roughly 20:30. It would be
8:30.
8:30. Yes, sir.
Okay. So it wasn't just margaritas on the receipt. There was dinner on the receipt, right?
Yes, sir.
And that's what he told you.
Yes, sir.
They had dinner and 3 margaritas apiece.
Yes, sir.
Do you remember how much all of the margaritas cost?
Roughly $30.
$26.94.
That sounds about right.
So those margaritas were $4.49 a piece. You divide 6 into that number. What kind of margarita can you get for $4.50?
I don't know what kind of margaritas they're serving there for $4.60.
Well, obviously not one with a lot of alcohol.
I can't comment on that, sir.
Do you know what time Dale made the 911 call?
Roughly, I'm going to say 10:52-ish.
I think you're spot on. 10:52. Do you know how far the restaurant is from the house?
It's only a couple miles away from his residence.
Take 5 or 6 minutes to drive, depending on the traffic.
Sure. I would say it'd take longer than 5 minutes, but sure. Yeah, probably 10-ish, sure, sir.
8:30 at night?
Yes, sir. Probably 10 to 15 minutes if I had to guess.
Okay. So there's 2.5 hours from the time they leave the restaurant, get home, and the 911 call is made, right?
Yes, sir.
What did they do for 2.5 hours?
Went
Do you
home
know?
based off of what he told me. That's the account that I have.
Did you ask him if they did anything else?
I asked him what they did that night, and he told me what they did that night.
With the guns? Did you ask him if they ever got up from the table?
Did I ask him if he got up from the table specifically?
He or police?
If they got up from the table at all?
During this firearm thing,
No, sir. I didn't ask specifically if he got up from the
did
table.
that mean anything?
No, sir.
How long that took and what was going on in between? That didn't mean anything.
No, sir.
Why not?
Again, I went there to investigate a shooting, which ultimately resulted in the death of Paulina Wright. What happened in those minutes is what I was investigating.
There was no indication in the house that any more alcohol was consumed when they got home, right?
No, sir. There was no indication of alcohol.
Nothing on the table,
No, sir.
nothing in the kitchen,
No, sir.
nothing in the living room.
No,
No
sir.
cups, empty cans. There was one can, but it was green tea. Did you see that?
I was at the house. I did not see any alcohol related items.
Now, as the lead detective, are you involved in directing the crime scene technicians in terms of what they look for and collect?
Yes, sir. Based off of my search warrant. Yes, sir. On what we're collecting.
Okay. Did the idea of looking for more alcohol occur to you that night?
That wasn't on my search warrant to look for alcohol,
Why not?
because the alcohol was not anything. I had no indicators of alcohol when speaking to him the first time.
Okay. So there was nothing about the way he talked to you or your observations of him that led you to conclude that he was under the influence of alcohol at all.
Correct.
So you didn't ask the text to look for
I didn't. I hear the
it. You
second.
did not ask the text to look for anything
Not alcohol related.
alcohol related,
No, sir.
but you didn't see anything.
Correct.
He told you that when she saw him start opening the Amazon packages with the gun cleaning stuff and started to disassemble and start cleaning his rifle, that she asked him to show her how it worked.
Yes, sir.
And at the point she asked that question, she came over the table and sat down across from him.
Yes, sir.
He told you he made the rifle safe before he handed it to her, didn't he?
I don't know what you mean by made it safe. By not having a magazine in it?
And it almost sounded like it was never fully assembled when he handed it to her.
Oh, he handed over, in his words, handed over the rifle to her and had the red dot light on for her to dry fire the weapon.
He told you when she finished looking at the rifle, he took it back from her
Yes, sir.
and set about to finish cleaning and putting it back together.
Putting away the firearms. Yes, sir.
And then he told you he saw her grab the handgun that was in a holster on the table.
Yes, sir.
That, he told you, he knew was Logan.
Yes, sir.
And he stopped what he was doing, put the rifle down, and got the handgun from her.
Yes, sir.
Got it out of the holster, took the magazine out, and cleared the round from the chamber. Did you see the magazine and the single round laying on the table in the area where he was sitting?
In the area where he was sitting?
Yes, sir.
No, sir.
You did.
No.
There's photographs of it. Did you look at the photographs?
I was there at the scene. The firearm that was in question was on Paulina's side of the table.
I said the magazine and the round. The magazine and the round were on his side of the table.
Okay. Yes, sir. I'm sorry. I misunderstood.
Okay. Did you see that?
Yes, sir. I was there.
Well, that's indicative of him unloading it like he said he did, right?
Yes, sir.
And the handgun itself had no magazine in it when it was found in Miss Wright's lap.
Correct.
4 bullets.
Correct.
And he told you that he forgot that he had loaded the rifle. That he pulled the trigger one time, it clicked. Then he charged the weapon and pulled the trigger again,
Yes, sir.
and it went off.
Yes, sir.
Does that process sound like resetting a trigger?
That would be the process in resetting a trigger. Yes, sir.
Okay, and it's a little more involved than that with an AR style rifle, right?
I don't know what you mean by the question.
Pull the trigger the first time.
Mhm.
Listen for the hammer to fall. You pull the charging rod out, except you haven't released the trigger yet.
Right.
While you're holding the charging rod out, you slowly release the trigger. You reset it. It clicks. Then you put the charging rod home. If the gun is empty, you can pull the trigger again and it's gonna, and you'll hear everything sync up and reset again. So you know it's gonna fire the next time you need it to fire. Right?
Yes, sir.
Did you ask him about doing all that?
He told me that when he pulled the trigger the first time, it was a dry fire. He pulled it the second time. The only way for that round to go forward is if the charging bolt went
Right,
forward.
I got that. There was a magazine with bullets.
Yes, sir.
Okay. What I'm asking you is, you ask him if he went through all those intricate steps to reset the trigger?
No, sir.
No. But that's how this weapon went off. Isn't that true?
I don't understand the question. How?
It was in the process of resetting the trigger based on what he told you that the weapon went off.
Yes, on the second pull of the trigger and charging the rifle, therefore putting a round in the chamber.
Did him being a deputy sheriff have anything to do with why you were arrested?
No, sir.
You wrote a report, right?
Yes, sir.
Page 2 of 3. This would have been your initial, and not your follow-ups. Did you write that based on Boileau's statements made on the initial 911 call, his spontaneous utterances during first contact, his admissions during my interviews with him, which align with the physical evidence observed, collected at his residence, and Boileau's carelessness while handling firearms given his profession? Did you arrest him because he was a deputy?
No, sir.
And had an accident with a firearm?
No, sir.
Why'd you write that?
That's for my probable cause affidavit.
Does that mean it doesn't have to be true?
No, the probable cause is that statement is adding to my probable cause statement.
Well, you just told me you didn't arrest him because he was a deputy.
No, sir. I didn't arrest him solely because he's a Marion County Sheriff's deputy.
It was part of the reason.
No.
According to what you wrote?
No, sir.
No?
No, sir.
How am I misreading that, Sergeant Kern?
The probable cause affidavit, based off of the set of circumstances that I had and his knowledge of firearms with him being a sheriff's deputy, coupled with everything else.
I get that. Him being trained to use a gun
Correct.
is relevant here,
Yes, sir.
okay? But that's not what you wrote.
I did not arrest him based on his profession.
So you don't believe that the law is applied any differently to law enforcement officers than to average citizens?
The law is the law, sir.
Right. Regardless of what you do for a living.
Correct.
And the same law should apply to all of us,
Correct.
regardless whether we're lawyers, judges, or policemen.
Yes, sir.
Do you really know exactly what happened to Alina Wright?
I do know what happened to her. Yes, sir.
How was Mr. Boileau holding the rifle?
How was he holding it?
Yeah.
He had to be holding the trigger or holding the gun in
Well,
such a
you're
way.
assuming. What did he tell you how he was holding the rifle?
Based on the evidence that we have, I can line up a trajectory of the bullet.
I asked you if he told you.
No, he didn't specifically tell me. No,
Did
sir.
you ask him?
No, sir.
Wouldn't it be helpful to know exactly how he was holding the rifle to come to the conclusion that this was a manslaughter and not just an accident?
To ask him how he was specifically holding the firearm?
Yeah, exactly.
No,
That's
sir.
how this happened.
No, sir.
You don't think so?
No, sir.
But you didn't ask.
No, sir.
So you can't tell the jury.
No, sir.
I don't have any other questions.
State any redirect examination.
One second. No further questions, Your Honor.
Members of the jury, do any of you all have questions of this witness? If you do, please raise your hands. All right, seeing no hands, state, is this witness released?
Yes, Your Honor.
Defense?
I do have one thing I would like to do with it, and I believe the state's agreed to let me introduce a piece of evidence out of the church.
That's fine, Your Honor. Yes.
Okay.
So I'm going to show you what's been marked for identification as state's exhibit or defendant's exhibit D.
Yes, sir.
You
Counsel, do you
recognize that?
say B as in Bravo?
B as in boy, Bravo,
Yes.
Baker.
Yeah, I recognize it. Yes, sir.
How do you recognize that first?
This is a picture taken off Miss Wright's cell phone.
From the extraction,
Yes, sir.
and that was provided to you by the technician that did the extraction.
Yes, sir.
Were you able to identify from the data associated with the photograph when the photograph was taken?
It was taken on Snapchat, I do believe. As far as a time frame, I cannot recall a specific time frame, but I want to say it was in the appropriate time that they would have been at the restaurant.
Okay. And does it appear to be them at the restaurant?
Yes, sir.
Your Honor, the defendant would move defense exhibit B into evidence as defendant's exhibit number one.
No objection.
Without objection, defense exhibit B will be admitted to evidence as defense exhibit 1.
May I publish the photograph?
Yes, sir. Do you want the overhead projector?
I'll hand it down the road.
Very well.
Please report.
Yes, sir.
And I have no other questions for Sergeant Kurt.
State any follow-up?
Not off that, no, Your Honor.
Members of the jury, any questions from any of you all based on the additional questions? All right. So state, is he released?
Yes, Your Honor.
Defense?
No objection.
Okay, sir, you're free to go about your day. Thank you for your time.
Your Honor, before state calls its next witness at this point in time, state would move into evidence what's been previously marked as Y for identification purposes, as states, I believe, 24. It's the training records of Leslie Dale Boyle.
No objection.
Okay, what's been marked for identification as states exhibit Y will be admitted to evidence as exhibit 24.
Your Honor, next state would call to the stand Kristen Killinger from Florida Department of Law Enforcement.
I do, yes.
You can be seated, ma'am.
Good afternoon. If you don't mind, can you please introduce yourself to us and spell your last name for record purposes?
My name is Kristen Killinger, Killinger.
And Ms. Killinger, where are you currently employed?
I'm employed at the Florida Department of Law Enforcement in the Orlando Regional Operations Center.
And what is your job title or job position?
I am a crime laboratory analyst in the firearms section.
How long have you been a crime laboratory analyst in the firearms section for the Florida Department of Law Enforcement?
For about 5 years.
And can you just kind of briefly explain to us what your job duties entail in terms of being a crime analyst at the Florida Department of Law Enforcement with firearms?
Primarily, I will test firearms to see if they're functional or not. I will also compare microscopically compare fired ammunition components, such as bullets and cartridge cases, to the suspected firearms.
And are you also familiar with the general working parts and layout of a firearm and how they operate generally?
Yes.
Can you kind of also explain to us what your educational background is to actually get to a position of this nature?
I have a Bachelor's of Science degree in Forensic Science from the University of Central Florida. I also completed a 2-year training program in the area of firearms identification.
Now, aside from your background education and training, do you also have to continue to do additional training as you hold this position?
Yes.
And what is the requirements of that training that you have to do? How often and how much do you have to do?
I have to do an average of 16 hours of continuing education per year over 3 years. So I will attend like lectures and conferences, as well as armorers courses, and then read articles.
Now, during your time as a firearm examiner for Florida Department of Law Enforcement, how many times have you examined firearms roughly?
I would say more than 600 times.
And is that about the same amount of times that you've also done comparisons with projectiles or casings?
Yeah, I would say I've done more than 1,000 comparisons.
And have you been able to render an opinion as to the comparisons of casings or projectiles to firearms before?
Yes.
And has that been in a court similar to this?
Yes.
About how many times have you been able to do that?
I think about 20 or more.
Your Honor, at this point in time, state would request that Ms. Killinger be able to give her opinion in terms of firearm ballistic comparison as well as the general operation of firearms.
Do you have any objection? Okay, you can continue, counsel.
So I kind of want to ask, did you receive items in reference to what would have been Ocala Police Department number 2024-0012-4192?
Yes, I did.
Okay, and what exactly did you receive from the Ocala Police Department to examine or review?
I received 1 firearm, 1 cartridge case, and 1 projectile.
And what was the firearm that you received?
I received a 5.56 by 45 millimeter caliber Daniel Defense Model DDM4 semi-automatic firearm.
And did you have an opportunity to examine this firearm personally yourself?
Yes, I did.
And did you have an opportunity to determine the operation and how this firearm actually operates and works?
Yes, I did.
So what I'm going to actually have you do is, if you don't mind, kind of give me a minute. I'm going to show you what's been previously introduced into evidence as that firearm. I'm going to have you show the members of the jury exactly how that firearm operates. And Your Honor, once she's done loading up, I'd also ask if the witness can step down to demonstrate to the jury.
She may. And counsel, y'all can move as you need to.
I'm going to ask the bailiff to remove this. All right, if you don't mind, if you could just step down. Now, if you don't mind, can you just walk through the jury, essentially the process of having the firearm as is, how you would actually be able to make the firearm shoot or dispel a projectile?
Yes, so this firearm has a magazine, which is kind of like a container that holds the cartridges. The magazine will be inserted right here into this hole. And then from there, you would pull back on this charging handle right here. You pull back and release. And in doing that, it will cock the firearm as well as chamber the first round from the top of the magazine. It will strip the cartridge off the top of the magazine and place it into the chamber of the firearm. From there, the trigger is ready to be pulled. Once the user pulls the trigger, the firing pin will be released and it will strike the primer, creating a spark, igniting the gunpowder inside that ammunition. The gunpowder will burn and create a lot of gas, and the gases are what push the bullet down and out the barrel. The gases will also push back on the bolt, and it will cock the firearm again, and then a spring will push the bolt back forward, stripping the next cartridge off the top of the magazine, loading the firearm. So now the trigger can be pulled again for the next shot.
Now, let me ask you this, because you were showing us pulling that charging rod back. Does that naturally stay back, or how does that work when you pull that back?
You just pull it back and then you let it go like that.
Okay. And we've heard a phrase of resetting a trigger and dry firing. I kind of want to take those step by step. So let's start with dry firing. What does dry firing a weapon mean?
Dry firing is just basically when the chamber is empty, pulling the trigger, and so nothing will happen when you pull the trigger.
Now, when you pull that trigger with the chamber empty, does the trigger change position, or does it alter the trigger in any way in terms of where it's set?
The trigger will move backwards, obviously because you're pulling it, and then it will be disconnected from the hammer internally, so it will kind of be limp or depressed. And then the process of pulling that handle back and releasing it again will reset the trigger so that it's stiff again and ready to be pulled.
Now, other than pulling that rod back all the way and releasing it, would there be any other additional steps required in order to quote unquote reset the trigger?
No.
So you don't have to physically alter the trigger or push it back into place or anything like that.
No, if the firearm's working properly, it will automatically reset the trigger.
And based off of your exam and review, was this firearm operating properly?
Yes, it was.
Let me ask you, is there any other way, other than that process you talked about of pulling that rod back, is there any other way to put a round in the chamber of that firearm?
The user can manually, if we call it hand chamber a cartridge, but other than that, even if you do hand chamber a cartridge, you still have to manipulate the bolt by moving that charging handle in order to cock the firearm.
If you put a magazine in that rifle and you pull the trigger without ever pulling that bolt back, will it ever automatically just put a round up into the chamber?
No, if you put the magazine in and the chamber's empty, you have to pull back on the charging handle in order to insert that first round into the chamber.
Can you also briefly explain to us what a magazine safety is?
So safeties are basically how a device internally usually that the manufacturer puts in their firearm to basically stop firing from happening. Some safeties are external, some are internal. A magazine safety is an internal safety, meaning that the user doesn't have to turn it off or on. It will automatically function during the firing process. So with a magazine safety, the magazine has to be inserted in order for the firearm to be able to fire. If no magazine is entered, then the trigger usually has something blocking it, so it cannot be pulled. And in this case, this firearm does not have a magazine safety, so the trigger can be pulled even if no magazine is inserted.
And is that common for that type of firearm to not have a magazine safety?
Yes, that's normal.
Now, I know I'm going to have you sit down here in a second, but I know you also mentioned that you received a casing and a projectile. Can you just kind of briefly demonstrating with the rifle, let the members of the jury know where the casing would be sent from and where the projectile would actually come out of the firearm as well?
So the projectile will come down and out the barrel, out the front towards the target. And then the cartridge cases will be ejected out of this hole once the bolt is pulled. Once it returns rearward, the casing will fly out the side. If you think of like in a movie, you're seeing the things flying to the side. Those are the empty cartridge cases.
Now, let's say you have a magazine in that gun that's loaded with more than one round. That gun fires. When we hear the term of clearing a gun, how would you clear a gun? What does that mean and what would you do to clear the gun?
So if you have a firearm that you think is loaded, you would remove the magazine by pushing this button here, and then the magazine will be able to be removed. And then from there, you would want to check that the chamber is also empty. So you would pull back on that charging handle, and then it will automatically extract and eject that cartridge that's inside the chamber. If you don't see that happen, then you would want to physically look with your eyes to make sure that the chamber's empty and there's nothing in there.
Thank you. So I know you talked about a little bit of it, that is part of what you do with your job process, but I kind of want you to explain it to us in a little bit more detail. We're going to start with casings first. Can you kind of describe to us the process of when you say you're doing comparisons on casings? What does that process look like?
So first I'll receive the evidence and I'll document what I have, what it looks like, if there's any damage on it. And then from there, I will look at it microscopically to see the microscopic imperfections that are present from the firing process on the back of that cartridge case. If I have a firearm to compare, like in this case, I will test fire that firearm and then use the cartridge cases that I test fired to compare it to the one that I received as evidence. I can do this using a comparison microscope. It's two compound microscopes connected by an optical bridge, so I can see two things at the same time.
Now, when you're looking at these two casings at the same time, what are you looking for?
So I'm looking at the microscopic imperfections. They appear as lines or striations, as shapes, depending on how the manufacturer decides to manufacture the firearm, they will look differently.
So let me ask you this, because I know you talked about microscopic imperfections, but are there also what I kind of refer to as class characteristics as well too?
Yes, so class characteristics are features that are determined prior to manufacture by the manufacturer. So this would be the caliber or the shape of the firing pin, the style of the marks that I'm looking at. If you think of your car in a parking lot and you're trying to find your car, you're going to narrow it down to cars with similar class characteristics. So that would be the make, the model, the type of car, the color of your car. So that's what I'm looking at. Once I see that my cartridge case that I have from evidence is similar to the class characteristics of my firearm, I will move forward and I'll look at the individual characteristics or those microscopic imperfections that are unique to that firearm. So if you think of your car again, what separates your car that's the same one that was made right after it? You're looking for the scratch on the side of your car or the bumper sticker in the back. So I'm looking at those similar features they're called individual characteristics that would happen during the manufacturing process or also during the use of the firearm over time.
And I want to ask you about that with and I know we're kind of using interchangeably, the individual characteristics or those microscopic imperfections. Have you ever had a situation where two different firearms have the same individual characteristics?
No, I have not.
So is it that every single firearm has its own individual characteristics?
Yes.
Now, I'm going to show you what's been previously introduced as state 18, is if you don't mind, if you can pull that out. And I know we don't have the dual microscope that you were explaining to us, but can you just kind of show the members of the jury what the area on the casing is that you're actually doing this evaluation and examination on?
Yes, so this is the cartridge case, and at the head of the cartridge case is the primer. There's a little tiny circle kind of inside of that. That's what creates the spark that's hit by the firing pin. So as the gases are building, they're actually pushing back on that breech face and on that firing pin, and it's creating like a stamp of the inside of the gun. So that's what I'm looking at.
And were you able to make, and I'll kind of go in turn here, were you able to make determinations in terms of the class characteristics of this projectile?
Yes.
What were those determinations?
The class characteristics that they were 5.56, 545 millimeter caliber, and then it had like a hemispherical firing pin impression. As I continued further looking at the individual characteristics, I could see consistency with the firearm.
And just to confirm, were you then able to render an opinion in terms of the casing to that Daniel Defense firearm that you received?
Yes, I could identify the cartridge case to the firearm.
And just kind of, for me in layman's terms, what does that mean that you identify the cartridge to the firearm?
So the agreement of the class characteristics and the individual characteristics was to an extent that I could say that this firearm fired that cartridge case.
Okay. Now, I'll let you put that away. And then you also had an opportunity to look at a projectile as well. Is that correct?
Yes.
And I'm going to kind of ask, the class characteristics and those individual characteristics or microscopic imperfections, are you looking for similar things in terms of the projectile as well when you do a comparison?
Yes.
And I'm going to kind of ask you to do the same thing you did with the casings. If you don't mind, can you just kind of show the members of the jury, I'm giving you what's been previously marked as states 21, is if you can just show the members of the jury where on that projectile are you doing your examination or where are you looking at for these markings?
So here's the projectile. There's the inside of the barrel has rifling, which is cut into the barrel during the manufacture process. It imparts the spin on the bullet. If you kind of think of like a football, the bullet will be more accurate as it's spinning down and out the barrel and traveling. So the rifling inside of the barrel will actually cut into the side of the bullet. So it's very hard to see, but it's down the side of the bullet here. It appears as like striations almost.
And again, were you able to do a similar comparison that you discussed in terms of projectiles from this firearm and projectile that you received?
Yes, I fired the firearm into our water tank, which is a tank filled with water, so I could recover the projectiles. And I compared those projectiles on my comparison microscope to this one, and I was able to identify that this bullet was fired from the firearm.
And that also means that it was the same class characteristics and same individual characteristics, correct?
Yes.
Your Honor, I have no further questions at this time.
Any cross-examination?
Briefly. Good afternoon.
Hi.
Prosecutor asked you about resetting the trigger on an AR style rifle. Are you familiar with a process involving an AR where one would, assuming the gun was in, right, pull the trigger and hold, listening for the hammer, then charge the weapon, at least pull the charge handle back, release the trigger, again listening for a click, and then set the charge handle, and then you pull the trigger again.
You're asking, am I familiar with this process?
Yes, ma'am.
No, I am not. No.
Ever heard of it?
No, I'm not sure why someone would do that.
Fair enough. Thank you.
State,
further
any
questions,
additional
Your Honor.
questions? Members of the jury, do any of y'all have questions of this witness? If you do, please raise your hands. Seeing no hands, state is she released?
Yes, Your Honor.
Defense?
No objection.
Okay, so ma'am, you're free to go about your day. Thank you for your time.
Thank you.
Members of the jury, does anybody need a break? All right, we're gonna take a break. This will be about a 10-minute recess. We'll be back at 3:20. Jurors of the courtroom council, you'll be back at 3:20.
Yes, Your Honor.
I live here. I said I live here.
Yes, sir. Anything to take up before we group back up?
No, Your Honor. No, Your Honor.
Defense?
No, sir.
Y'all can be seated. Thank you. Are we ready to bring the jury back in?
We are, Your Honor. The next witness is the medical examiner. The family has been informed the next witness is the medical examiner and their owner.
Okay.
Thank you, Your Honor.
Ready for the jury?
Yes, sir.
Okay. And for our friends with the television camera, my understanding is that this is being broadcast on a 30-minute delay and that there will be no footage broadcast of these photographs. Am I correct?
Correct.
Counsel, y'all can be seated. Ladies and gentlemen, welcome back. State, you can call your next witness.
State calls Dr. Rachel Lang.
I do.
You can be seated.
Good morning, ma'am.
Good morning.
Would you please introduce yourself to the jury?
Hi, I'm Dr. Rachel Lang. That's Lange. I'm an associate medical examiner with the District 5 Medical Examiner's Office in Leesburg.
Can you describe for the jury, first of all, what do you do as an associate medical examiner?
Yeah, so I'm a doctor. My training is in pathology and forensic pathology, and meaning my job is to determine the cause of death by doing autopsies.
Can you describe to the jury your educational background and training that allows you to do that job?
Yes, my medical degree is from the University of Miami, followed by pathology residency at Mount Sinai Hospital in New York City, and additional training in forensic pathology through a fellowship at the Office of Chief Medical Examiner of the City of New York.
And how long have you been a medical examiner?
Oh, over 10 years, since 2009.
You said earlier you're a doctor. You're licensed to practice medicine in Florida.
Yes.
And you also mentioned that your duties include the performing of autopsies. What's an autopsy?
An autopsy is an examination performed on the body after death, which consists of an external examination where the body is identified and we look for injuries or signs of disease, followed by an internal examination, which is done by an incision made on the body to allow us to see the body's organs.
Can you estimate about how many autopsies you performed in your career?
Well, conservatively, a few thousand.
You mentioned the term pathology. What is pathology?
Pathology is a specialty of medicine, and as the broad field, pathology involves looking at tissues or laboratory tests to make diagnoses. So, for example, when you have a biopsy or you have blood work done, that's all overseen by a pathologist.
What is forensic pathology?
Forensic pathology is an additional subspecialty of pathology, which is where we do additional training to specifically to perform autopsies to determine cause of death. And forensic basically means applying to the matters of court. So we use the field of pathology to deal with questions posed in the court.
So because of your additional specialized experience, are you considered a forensic pathologist?
Yes.
Have you been permitted to provide opinion testimony in a court of law before in the area of forensic pathology?
Yes.
Not how many times?
Dozens of times.
Your Honor, at this time, the state would request this witness be permitted to give opinion testimony in the area of forensic pathology.
I have no objection.
All right, you can continue, counsel.
You direct your attention to September 21st of 2024. Did you perform an autopsy on Paulina Wright?
Yes.
How did she get to the medical examiner's office?
She was transported to our office by a contracted transportation service.
And where is the medical examiner's office in the Fifth Circuit?
It's in Leesburg, Florida.
That's in Lake County?
Yes,
Does that also cover deaths that occur in Marion County?
yes,
Is there a case number assigned by the medical examiner's office to each autopsy that's performed?
yes.
And what was the medical examiner case number associated with the autopsy done on Paulina Wright?
2024-2220.
When you did your external examination of Miss Wright, did you determine how tall she was?
Yes,
How tall was she?
she was 5'6".
And did you also determine how much she weighed?
Yes,
How much did she weigh?
181 pounds.
How old was she?
Her reported age was 25, and she appeared to be consistent with that age.
During the course of your autopsy, did you also take photographs documenting her appearance and various injuries that you may have observed?
Yes,
Showing what's been marked as State's Exhibit X for identification. Can you take a look at those photographs and tell me if you recognize them? I could have a display as well. Thank you.
yes.
Generally, what do those photos show?
These are photographs taken of Paulina Wright at the time of the autopsy.
Do they fairly and accurately depict your observations of the injuries you saw in this right?
Yes,
It's time to state removed X into evidence of State's 25.
No objection.
Without objection, State's Exhibit X will be admitted into evidence as State's Exhibit 25.
May I publish, Your Honor?
You may.
Showing you photograph 1 of State's 25. Is this Paulina Wright, the woman upon whom you performed an autopsy?
yes,
And does the number on the sticker in the bottom match your medical examiner case number?
yes.
When you did the external examination of Miss Wright's body, specifically her head, what did you notice as far as injuries?
The most notable thing is that she had a gunshot wound of her head.
Can you describe the location of that injury on her head?
Yes, the entrance wound of the gunshot path was on her forehead, basically between her eyes, and the exit wound was on the back of her head.
You described the wound we see in photograph 1 here, an entrance wound. How can you tell if a wound is an entrance wound versus an exit wound?
Entrance and exit wounds have typical features. So, for example, an entrance wound typically is, circular, oval in shape. It has a punched out look to it, and often has abrasion or scraping around the skin of the margin, while an exit wound typically is more slit-like or stellate in shape.
You said around the edges of the margin. What is the margin?
The margin, just the skin around basically the defect, the hole that the bullet leaves.
When you examined this entrance gunshot wound to the center of her forehead, was that entrance circular or was it slightly irregular?
It was slightly irregular.
What do you mean by that?
So instead of being a round or oval shape like we typically see when a bullet travels straight through a tissue, it had a bit of an irregular shape, and the abrasion that you see around the defect is also irregular instead of being circumferential.
In your training experience, what is the general cause of an entrance wound of a gunshot wound being slightly irregular?
This tends to happen when the bullet is no longer traveling straight. So if it hits something else or passes through something else, and it enters, at a unusual angle instead of straight on, it can create an irregular look to the wound.
I'm going to ask you a few questions about that later on. Describe the damage that the projectile did as it struck the center of her forehead and traveled through her head.
It caused extensive damage, which you can see the reason her face looks somewhat distorted. There were many, many fractures of the base of her skull, the top of her skull, and her brain through the bullet path.
Was this wound fatal?
Yes.
You mentioned that there was an exit wound as well. I'm showing you photograph 2 from States 25. What do we see here?
We're looking at the back of her head, and as typical in an autopsy, we will shave around a wound so that we can see all of its characteristics. So we're seeing a shaved area of her hair on the back of her head, and the large slit-shaped tear in the skin we're seeing is an exit wound.
You can tell this is an exit wound because of how it appears in contrast to the entrance wound.
Yes.
Using your own kit, because the picture is a little bit deceptive of where the shaving is and where the injury is, can you point to the jury in your own head where the exit wound would be?
Yes, it's the back of her head.
Obviously, since there is an exit wound, I'm assuming you did not locate a projectile inside of her head.
That's correct.
Describe the path that that projectile took after it entered the front of her forehead.
So it continued basically straight through her head, damaging the skull and the brain before exiting through this defect here. So it's pretty much front to back, straightforward, without really any significant deviation to the right or left or up or down.
Did you locate another injury on Miss Wright's body?
Yes.
Where was that?
She had another gunshot wound on her right second finger or index finger.
Showing you photograph 3 from stage 25. What do we see here?
We were looking at a photograph of 2 of her fingers. The one in the center of the screen is the back of her right second finger or index finger, and we're seeing a gunshot entrance wound right below the knuckle.
And can you describe the damage that the projectile did after it entered the right index finger?
It basically went straight through her finger and came out on the other side.
Showing you photograph 4 of stage 25. What do we see in this photo?
So now we're looking at her hand with the palm up, and the finger that's extended is her right index finger, and we're seeing the exit wound in the middle of her finger.
And photograph 5 of stage 25. What does this show?
This is her hand seen from the side, and what you see is a probe. This is something we often use in an autopsy to try to clarify a bullet path. And this is just to demonstrate that it did go directly all the way through her finger.
You said earlier that the gunshot wound, the entrance wound to the center of her forehead was slightly irregular, consistent with the projectile striking something else before it entered her forehead.
Yes.
If only, considering that one projectile was found at the scene, one casing was found at the scene, and the injuries that you saw, are the injuries and appearance of those injuries consistent with the projectile striking the outside of the victim's finger, traveling through the palm side of that finger, and then that same projectile striking her forehead?
Yes.
Did you locate any soot on either the entrance wound to the back of her finger or her forehead?
No.
What is soot?
Soot is basically burned gunpowder. So in addition to the bullet that comes out of the muzzle of a gun, there is also burned gunpowder or soot and unburned gunpowder fragments.
What does the lack of soot on the entrance wounds, either the back of her finger or her forehead, tell you about the distance of the barrel of the firearm to the injury?
The absence of soot basically means there's nothing to show that it was a close range wound. So when we don't see soot, it's not consistent with the muzzle being very close to the surface of the skin where it struck.
What is meant by the term stippling?
Stippling refers to small dot-like abrasions that you can see around an entrance wound, which is caused by the unburned gunpowder fragments striking the skin.
Did you see any evidence of stippling on either the entrance wound to the back of her right finger or the entrance wound to her forehead?
No. And
what does the lack of stippling tell you about the distance of the barrel of the firearm that shot that projectile from the wound?
So again, we see stippling when the muzzle of the gun is close enough to the skin for those unburned gunpowder fragments to actually reach the skin. So we only see that up to, in general, from a few inches to about 1.5 feet or 2 feet, depending on the weapon. So it tells me the lack of these features, the soot and the stippling, tells me that likely the distance of the muzzle of the gun is more than at least 2 feet.
During the course of your autopsy, was a toxicology screen done? Was a sample taken from her body?
Yes.
And was that toxicology sample then sent to a lab?
Yes.
Did you get the results of that toxicology?
Yes.
First of all, how do you go about collecting a sample to send to toxicology?
We collect a number of body fluids at the time of the autopsy, most importantly blood. We collect in laboratory tubes and send to a toxicology laboratory.
what were the results of the toxicology analysis done on Paulina Wright's blood?
I showed the presence of alcohol. Her blood alcohol concentration was 0.046.
Did 0.046,
Yes,
and if the legal limit to drive is generally a 0.08, it's about half that?
correct.
Okay. Did that presence of alcohol cause or contribute to cause her death in any way?
No,
Did you notice any other injuries to Miss Wright's body or medical conditions that caused or contributed to cause her death?
no.
What's meant by the phrase cause of death?
The cause of death is the specific disease or injury that leads to the physiological change in the body, resulting in no longer being compatible with life.
And what did you determine the cause of death to be for Paulina Wright?
A gunshot wound of the head.
What does the term manner of death mean?
The manner of death refers to the circumstances around which a death occurs. And this is where we generally will classify a death as natural, homicide, accident, or suicide.
And is there a fifth, undetermined?
Yes, sometimes we do have to say undetermined if we just don't know.
And what did you determine the manner of death to be in this case involving Paulina Wright?
The manner of death was homicide.
And from a medical standpoint, what does that term homicide mean to you?
It simply means death caused at the hands of another.
Thank you, doctor. I have no other questions, Your Honor.
Cross-examination.
May I please support? Mr. Johnson? It is afternoon.
I think so, yeah.
Now, assuming that one bullet caused the injury to Miss Wright's index finger and to her head, what you can tell the jury is her index finger at some point must have been between the muzzle of the weapon and where it hit her in the forehead.
Yes.
Any way for you to tell what she was doing with her hand at the time it was struck?
No.
She could have been pushing her hair out of her face
Yes.
because it did enter the back, right?
Yes.
Not the front. So her hand was in more in this position.
Yes.
And based on your observations of her hand and her forehead, you can opine that the weapon was more than 2 feet.
Yes.
Width of a normal dining room table is about 3. Do you agree with that?
Yes.
So it could have been from the other side of a dining room table.
Yes.
And Ms. Wright's blood alcohol level at her height and weight was 0.046.
Yes.
Now, did you also find evidence that she had had a full meal prior to her death?
I have to refer to my report. Yes.
Could you even identify what kind of meal she might have had?
Yes. I described that she had partially digested food, including green pepper, tomatoes, onion, light meat, and tortilla.
Sounds like Mexican food.
Yes.
Would the fact that she had a stomach full of food have an impact on her blood alcohol level? Or at least the way the alcohol would have affected her?
Yes. Having a full stomach full of food can delay absorption of alcohol.
And do weight and body size also have an impact on blood alcohol level?
Yes.
So would it be fair to say that a larger, heavier person who consumed the same amount of alcohol as a smaller, lighter person is probably going to have a lower blood alcohol level?
Yes.
Now, You explained for Mr. Buxman that the homicide word that you use means a death caused by the volitional act of another person.
Yes,
I'm right with that.
yes,
Homicide, the way you're using it, does not mean that the killing of Miss Wright was criminal. Is that correct?
yes, that's correct.
Could have been the result of an accident or negligent act.
Yes,
I don't have any other questions.
State any redirect examination?
Very briefly, Your Honor. The blood alcohol content of 0.046 in her blood, does the body stop metabolizing alcohol once she's deceased?
yes,
So that would be the blood alcohol content at the time of her death.
yes,
Okay, it wouldn't change after she died in a short period of time afterwards.
yes.
Okay, thank you.
Anything else?
Nothing.
Members of the jury, do any of y'all have questions of this witness? All right, seeing no hands, is she released? State,
She is, Your Honor.
defense?
No objection.
Are you free to go about your day? Thank you for your time back. State, you can call your next witness.
Your Honor, at this point, state rests.
We'll give Dr. Lang a moment. Members of the jury, the state of Florida has rested its case. So there are some procedural matters that we have to take up outside your presence at this point. So I'm going to have you go back to the jury room again, and we'll get you back in as soon as we're able. This may take some time, so please just be patient. Leave your notepads here face down. Don't discuss the case with one another. If you use your electronic devices, don't use them to try to learn about the case with people or places involved. We'll see you back shortly. Counsel, you all to be seated. Mr. Caddy, where do you have to go from here?
Yes, sir. And I neglected to pull the little handful of cases there are on this subject. But there are a couple. The defendant would move the court to enter a judgment of acquittal based on the state's failure to present a prima facie case of manslaughter. The evidence establishes, number one, that the state has no evidence other than what was received from Mr. Boyd. Every physical piece of evidence corroborates what he told the law enforcement officer. And what he told the law enforcement officer was, it was an accident. Contrary to the opening statement by the state, at no time did Mr. Boylan ever tell Detective Kern that he pointed the rifle at her and pulled the trigger. We were pointing the rifles at each other, and then when Kern asked him about it, he said in the general direction. As he explained, they were sitting on the opposite sides of the table. There was no intentional, Mr. Boylan made no statement to Kern indicating that he raised the rifle, aimed it at Miss Wright, and pulled the trigger. There is no evidence of that, which is what the state has argued or suggested in an opening statement that their evidence would show. That has not happened. And I would submit, Your Honor, there is no evidence from which a jury could legally return a verdict of manslaughter.
At this point in time, the court is bound to view the evidence in the light most favorable to the state, including all inferences that may be appropriately drawn from the evidence. Based upon Tillman versus State, 842 Southern Second, 922 Florida Second District Court of Appeal, 2003. Navarro versus State, 433 Southern Second, 1011 Florida Third District Court of Appeal, 1983. Dellinger versus State, 495 Southern Second, 197 Florida Fifth District Court of Appeal, 1986. The court will find that based upon the evidence presented, there has been a prima facie case made of manslaughter from which the jury could base a finding of guilt. Obviously, this is a case where it is in the province of the jury, not the court, to determine what happened and what was proven. So the motion for judgment of acquittal will be denied.
Yes.
Where would you like to go next?
Well, they're prepared to go forward, but my assumption, perhaps dangerously, was that I would be able to present Mr. Boyley's testimony.
Okay.
Because it will be fairly lengthy.
How long do you think his testimony will take?
The direct, probably 45 minutes to an hour.
State, if you had to make an educated guess about how long cross-examination would take?
I would say probably at least 30 minutes. I mean, it also depends to what other additional information may or may not come out during the direct. So I would say at least a rough guess of at least 30 minutes.
I don't intend to present any other evidence.
To also help the court in terms of timeline and all, I don't anticipate, I would be the one giving the closing argument tomorrow, Your Honor. I don't anticipate a very lengthy closing. I would say at max, initial closing and rebuttal no longer than probably about 45 minutes to an hour. And I usually kind of over guess on mine.
What I'm wondering is whether or not his testimony may lead to rebuttal evidence. If so, by whom and how long that person may need to get here.
I don't foresee, Your Honor, any rebuttal evidence being necessary by the state with his testimony. Kind of doing a short conferral with Mr. Buxton, I think he agrees as well.
I can't envision that occurring.
Okay.
I certainly can envision the jury wanting to hear his recorded statement again during their deliberation.
Sure. Okay. Let's do this, and I'll tell the jury that we wrapped up a little bit early. We'll recess until the morning. We'll start at 8:30 tomorrow. I'd like to put the afternoon to good use and try to get the jury instructions as close to an order as we can for them.
Absolutely.
Okay. All right. Let's go ahead and bring them back in. I'll let them know. Council, you all could be seated. All right, ladies and gentlemen, it's about 10:04. Rather than risk going past 5 o'clock today, what we're going to do is we're going to break for the day. Okay, we'll have you back tomorrow morning. We'll begin court at 8:30. Now, there's some instructions I have to give you before we break for the day. First, you all have notepads here. Those need to remain here in the courtroom. Deputy Boucher will pick them up and he'll keep them under lock and key until tomorrow when they'll be handed back out to you. Second, there has been, as you have no doubt seen, a camera here in the courtroom throughout the trial. I do not know how far and wide and into what corners of the internet today's proceedings may have been broadcast or where they may be found. So for that reason, I'm going to instruct you all tonight to not watch any television news, to avoid the use of your cell phones and electronic devices, including social media. Okay? Do not watch local news. Do not read local news. Do not watch anything that is court related. Okay? If you go home to friends or family, and they mention that they have seen something about the trial. Remember what I told you yesterday. Tell them that you are a juror serving on the case and that they cannot talk to you about it. And ask them to stop. Okay? It is very important that you not be exposed to anything other than what you hear in your role as jurors. So I'm going to order you all to do that. That's very, very important tonight. Okay, we'll get going at 8:30 tomorrow morning. Have you all put your lunch orders in for tomorrow for Jimmy John's? Deputy Boucher will take care of that here before you all leave. So I hope that you have a good night, get some good rest, and we'll see you back. I'd like you here back in the jury room by 8:15 in the morning. If you want to get here a little early, obviously you're free to do that. We're all here. So see you tomorrow morning. Thank you for your time and attention today. Yes, ma'am?
Did you want our names written on the front paper?
That would help Deputy Boucher in the morning. So if you all don't mind doing that, take a second to do it. He'll be able to hand them out a little more quickly. So everybody's done writing, so leave your notepads here. We'll see you all back tomorrow morning. The jury's left the courtroom. Y'all can be seated. I'd like at this point to go ahead and have our charging conference. If y'all don't mind, give me a moment. What I can do is I can put the jury instruction draft up on the television, and then we all can follow along. Would you rather follow along on the one big screen, or
However you want, Your Honor.
we'll just do it the old-fashioned way? All right, the most recent draft I sent out would have been yesterday morning at about 8:15. All right, let's start with 3.1, introduction to final instructions. Any objections, state?
No, Your Honor.
Defense?
No, sir.
3.2, statement of charge. Any objections, state?
No, Your Honor.
Defense?
No, sir.
7.1, introduction to homicide. State, any objection?
No.
Defense?
No, sir.
Subpart of 7.1 is justifiable homicide. Any objection, state?
No, Your Honor.
Any objection, defense?
No, sir.
Excusable homicide. Subpart of 7.1, state, any objection?
No, Your Honor. I see you have a highlighted section that's kind of scratched out.
Yes, sir. I was not sure whether or not I would be reading justifiable homicide to the jury. If I am reading it, I can define dangerous, or I could either redefine great bodily harm a second time, which is defined differently in excusable versus justifiable homicide. And I'd like to know if you all would like me to read what I crossed out the sentence, an object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. I don't believe that's appropriately given that a firearm is by its design intended to inflict bodily harm.
Correct.
Defense, are you agreeable to that being removed?
Yes, sir. I have no problem eliminating that language.
Would you like me to read the definition of great bodily harm a second time in excusable homicide?
No, sir.
7.7, manslaughter. So I drafted a couple of different proposals for element number 2. If we were to go even with proposal 1, everyone agrees that procurement as a theory of prosecution is out, correct?
Correct.
Yes, sir.
All right. So what do you all think about proposals 1, 2, and 3? I prefer 2 or 3.
I prefer 3.
I think I'm leaning towards 3 as well, Your Honor.
Okay. The first subpart of element 2, Leslie Dale Boileau Jr. intentionally committed an act or acts that caused the death of Paulina Wright. I was inclined to omit or acts because I believe that this would be a single act. defense agreeable to more acts coming out?
Yes, sir.
Okay.
Depending on what they're gonna argue.
Well, let's leave it at.
I'm kind of inclined to leave it in at this point, Your Honor.
Okay. I mean, arguably. Okay. I understand. Okay. All right. There's a definition of to procure. Everyone agrees that can come out. State,
Yes.
defense.
Yes, sir.
Okay. Any other requested modifications to 7.7 manslaughter? State
No, Your Honor.
and defense.
Yes, sir.
Let's move on to 3.3A, aggravation of manslaughter by carrying, displaying, using, threatening to use, or attempting to use a firearm. I've lined through on my draft I provided to you all those portions of the instruction that I don't believe need to be given in the definition of firearm and weapon.
I would agree.
That's fine. It always became a tongue twister.
Yes, sir. All right. So the firearm will be limited to be defined as any weapon which will is designed to or may readily be converted to expel a projectile by the action of an explosive. And then I will remove the definition of weapon. All right, with those changes, any objections? State,
No, Your Honor.
defense.
Yes.
All right, plea of 3.7, plea of not guilty, reasonable doubt, burden of proof. That's standard. Any objections? State,
No, Your Honor.
defense.
Was there any change made to that on September 12th?
No. Now, last summer they changed it to include the sentence proof beyond a reasonable doubt does not mean proof beyond all doubt, but that's the most recent change.
That's fine.
All right. In the draft, we had 3.8 evidence of employment. I have previously ruled that that would not be given, so I will remove that. And I understand that is over the defense's objection. All right. 3.9, weighing the evidence. 1 through 5 is given in all cases. Let's talk about 6, 7, 8, 9, and 10. I believe 9 and 10 will be able to come out. State, defense, agree?
Correct.
Yes, sir.
I also believe number 6 could definitely come out.
Defense?
I agree.
All right.
Frankly, I think so.
State, are you agreeable to 7 being removed?
I'm fine with that as well, Your Honor.
There has been some indications of prior inconsistent statements, so
Yes.
8 will be left in, renumbered as 6. All right. We do have law enforcement witnesses, so I will instruct the jury on consideration of their testimony.
Yes.
Defense, agree?
Yes, sir.
All right. Expert witnesses, there have been persons here who may be considered experts by the jury. State, we'll leave that in. You agree?
Yes, Your Honor.
Defense?
Yes, sir. Even though the Supreme Court's told us not to call them experts.
Yes, sir. No, I most certainly don't. All right. We have the accomplice testimony paragraph. Everyone agrees that can come out.
That can
Yes,
come
sir.
out.
All right. Testimony of a child. There have been no children who have testified.
Yes, sir.
Correct.
All right. And then we have the defendant in this case has become a witness. I'm going to leave that in anticipation of Mr. Boileau testifying tomorrow morning.
Yes, sir.
I will take out 3.9A, defendant not testifying. Agree, state, and defense?
Yes, Your Honor.
Obviously, Mr. Boileau, if you change your mind tomorrow morning, I understand you've made a tentative decision at this point, but you're free not to. And if you choose not to testify, we'll just add this stuff back in. It's not a big deal, so I don't want you to feel pressured one way or the other. You'll be able to think about it over the night and talk to your lawyer. All right, 3.9B, defendant statements. State, any objection?
No.
Defense?
No, sir.
3.9C, eyewitness identification. I always include that in my proposed draft of instructions. I don't believe that this is a case to which it applies.
No, Your Honor.
That will be removed in its entirety. At that point, I'll give the instruction on closing argument.
Are you going to instruct the jury prior to closing
I
argument?
will do all that up to 2 point. Yeah, this will be, when I read the instructions, we'll get to 2.7. I'll read that, and then at that point in time, state, defense, make closing.
That is a procedure with which I have some familiarity.
All right, 3.10, rules for deliberation. I'm gonna leave I'm gonna leave number 7 under rules for deliberation. I do not know whether the jury will want to ask Mr. Boylo any questions tomorrow, and if so, whether or not they may not be appropriately asked. So I will leave that in, and we'll deal with that tomorrow. Let's see. Other than that, any other requested changes to 3.10?
No, Your Honor.
We have 3.11 cost sharing instructions. State any objection?
No.
Defense? All right, we have 3.12 verdict. State any objection?
No, Your Honor.
Defense?
Yes.
Let's look at the verdict form. We have the style of the case up at the top. The jury finds as follows as the defendant in this case. Check only one. A, the defendant is guilty of manslaughter. Interrogatory. If you check A, you must answer the following question. Check yes or no. Did the state prove beyond a reasonable doubt that during the commission of the offense, the defendant personally carried, displayed, used, threatened to use, or attempted to use a firearm? Yes or no. And B, the defendant is not guilty. So said we all, dated this blank date of October 2025. Any objection, state?
No.
Defense?
No.
We have 3.13, submitting the case to the jury. Now, I have something highlighted at the bottom there.
Yes.
I often tell the juries you will not have a means in the jury room to play audio or video recordings. If you wish to view or listen to any audio or video recordings, we will do that here in open court, so please request that in writing. I have procured from court administration a laptop computer that is not connected to the network. It's not connected to the internet. The only things that are on it are programs that the jury could use to play recordings. What we've done the last couple of trials we've had is we've taken all the exhibits that are forms of media. We've put them on the desktop directly. And we've labeled them. States Exhibit A, States Exhibit B, States Exhibit C, or 1, 2, 3. We've done the same for defense exhibits that are forms of media. That way the jury can watch them in their discretion in the jury room, be able to consider them, talk about them, and deliberate while they're watching, as opposed to having to come out here, sit here, watch a video, not talk, and then go back. And if they want to watch part of it again, they're left telling us to rewind it, whatnot. My preference would be to give them the ability to watch all of that during their deliberations in the privacy of the jury room. State, are you agreeable to us using that procedure?
Yes, Your Honor.
Defense?
Yes.
I will take out that paragraph then, and I will give them some instruction about how to use it when we get to that part of the instruction. I've ad-libbed that in the past. Do y'all trust me to do that off the cuff tomorrow?
Yes, Your Honor. I've seen you do it before. I'm fine with that.
I'm sorry, I didn't hear you.
Are you comfortable with me instructing them how to use the laptop to watch the videos off the cuff?
That's fine. My assumption is something won't work, so.
No. First time for everything. It's worked. We've tried it in the past. We'll see how it goes tomorrow. All right. Very good.
I would request that ammunition not be sent back at the same time as firearms.
State?
Locks, be damned.
That's fine, Your Honor.
Okay. All right. I'll fashion some instruction about how the ammunition will not be sent back. The firearms will be sent back. The ammunition will not. And if they would like to see and inspect the ammunition, they may do so. Please request that in
Or
writing.
swap it.
And we'll swap it. We'll take the firearms and have those out here. Send the ammo back. But I'll fashion something with that and get it and let you all see it in the morning. Okay. All right. All right. What I will do, counsel, I will email this draft to both of you, all three of you. If you want to look over it once more before morning in the event there's something we've overlooked.
Yes.
That would be
Yes, Your Honor.
helpful.
So we're leaving or acts.
Correct. council. I sent you all the email. Let me know if you receive it.
Yes, I just received it. Yes, Your Honor.
I haven't, there it is. Okay. I was gonna say, I haven't yet, but I have.
Okay.
IT provider inflicts the most ridiculous filters on my emails,
Fair enough.
notwithstanding the fact that I own all of the equipment.
Okay. Anything else, council, we need to take up before morning?
I don't believe so, no, Your Honor.
Yes.
Okay. All right. Mr. Boiler, I'll see you back at 8:15 in the morning. Give some thought tonight to whether you wish to become a witness. Okay. You and I will have a conversation in the morning, like I talked to you about on Monday yesterday, to make sure that you're making whatever decision you make freely and voluntarily. Okay. But talk to your lawyer about it. Give us some thought. We'll see you back. I'd like you all back at 8:15 tomorrow. If I can conduct that colloquy before 8:30, we should begin promptly at 8:30. I think I have a motion to set bond at 8 o'clock. So hopefully the bus with inmates will be available or be here tomorrow morning at 8 o'clock.
It's not another open plea, is it?
No, sir. No, sir. We got going at 8:33 today, so it didn't push us back by much. So, all right, very good. Thank you, council.
Thank you, Your Honor.
All right, after reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. So do y'all want to set this in 2 weeks, come back, and I can hear whatever evidence you all want to present? Otherwise, PSI is 12 weeks.
The judge is saying, if you don't want a PSI, like I was telling you what that was earlier, there would be an interview with probation with regarding to drug treatment, all of the things that were involved in your life, where you work, your education, and so on. We can do that. It's 12 weeks. That's 3 months, right? The judge says if we don't want to do that, we can waive a PSI and come back in here. Of course, we can bring your fiance and.
I'll waive the PSI.
You sure you want to do that?
Yes.
Okay. We'll waive, Judge.
All right,
Thanks for allowing us to confer.
no problem.
Spot.
All right, so how much time do you all need for any witnesses you would like to come in?
Judge, I believe the only witness he was telling me about in his interest that you've spoken to directly is he wanted his fiance to be able to come in before November the 18th, which
Or
is
14th is when her Labor Day, when she goes,
expecting a child. So I
All right,
know,
we can recall it back in 2 weeks.
but I know what you're asking about the time, but that's all I'm saying. I'm just bringing you up to date on everything. I think it's the only witness we would have. Does that sound like the only person?
yeah.
Is your mother going to show up?
My
there?
mom, I'm pretty sure might show up as well.
All right.
All right, so
What's happening?
I tell you what, we can recall it in 2 weeks, and if for some reason you don't have your witnesses by then, or you need an extension of time, the court will give you extension of time. Or if you have some witnesses who are not able to come, but they can appear by Zoom, if the state has no objections,
No objection.
then they can be allowed to appear by Zoom. So they can either appear in person or appear by Zoom. All right, Ms.
Thank you.
Ferguson, you're welcome. Ms. Ferguson, I need a reset date for 2 weeks. All right, so we'll be back on October 15th. I said 14th. Yes. No, no, no.
Yeah.
Yes.
To go ahead and have a seat. Probation talk to you about the form.
All right. All right, where's Navarro? All right, let me see though. Well, have you called, the interpreter down? All right, thank you. Scott, are you ready on yours yet or no?
We're finalizing, working it out. I think.
Okay, all right, thank you. Anyone else?
I'm not yet, we're still working.
They're gonna bring an interpreter down very quick and I'll take yours up. It's less than 5 minutes. Who else is over in the box?
Yeah. This is.
So what? All right. Which one?
Your Honor, we would like to see the stipulation.
Oh,
thank you. Actually.
Yeah.
Now it makes sense when you ask what kind of.
Sometimes there's not a class for everything, but if you're placing somebody on probation, you're supposed to be seeking to rehabilitate them. So sometimes there's not a class for something. And then. Oh, they filed a motion. Yeah, so, I mean, there's nothing to be ready for. Where's Deputy Laura? And if you talk to, no, that's what you had me sign. Okay. And if y'all just give me a moment on Miller, just give me a second. So what? Can you call the interpreter?
Yeah.
All right. All right, so everyone, if everyone and defense attorneys, if you can go forth and let everybody know. If y'all would stop, please checking the trial court certification and whether you have a right to appeal or not to have a right to appeal, because that's my job. And when y'all do that, sometimes you get it wrong. And then there's like scratching out and initially. So if y'all could stop doing that and spread the word to stop doing it, I would greatly appreciate that.
I'll redo mine.
Thank you.
Sorry. I didn't
No, it's just that sometimes people check the wrong box and then I have to scratch through whole lines and initial things. And then if it goes up on appeal, then I have to get it back saying, what did we mean? Let's go on the record. It's just a whole host of things.
And now I know.
See, yeah.
I've been forewarned.
Hi. Hi, she'll meet you over there. And actually, she doesn't need you. I need you for her client. Okay.
Yes.
And Monica, whenever y'all are set up and ready to go, just come on up. All right. Yes. All right. All right, so on Jonathan Navarro and
Ms. Jones.
Jonathan Navarro.
Jones was doing it.
All right, so Ms. Guerrero, I know you were recently appointed and you were appointed yesterday. So what I'm going to do, and the reason why you were appointed is because the previous attorney stated they were not on the first degree will. And they said they didn't speak Spanish. So you've been able to communicate with your client?
Yes, Your Honor, in his native language, Spanish.
All right. So what we're going to do is I'm going to recall this. And based upon the charges, I'm going to recall this in 45 days to see where you all on discovery. Ms. Ferguson, I need a 45-day reset for discovery. All right, so November 13th will be discovery and state. Yes. This is family violence. All right, counsel, are you aware if there are any CPS records? If there are, could you let the state know they need to seek those out?
I literally don't know what is in the file because I was appointed less than
Yes.
24 hours ago. I did review the police report briefly today, and I did see there was a telephone dump that was not present in the file. I did inform Ms. Jones, and she said that she was going to be able to get that for me this week, and I'm going to bring a device that can hold a terabyte of information.
All right, and can you make sure that there are CPS records, they have access to those?
Ashley Jones for the record.
Oh, we're not on the record.
just kidding.
Yeah, but I appreciate that.
Yes, Your Honor.
All right, so they'll look for that. So if you could already go ahead and give me the protective order to sign, just in case there are some. And then this is going to come back on November 13th. On November 13th, it's just to make sure that your attorney at least has access to the information. Is there anything else, defense?
No, not at this time.
State?
Not from the state, Your Honor.
All right, then we'll bring you back on that date.
Thank you, Your Honor. May I excuse?
Yes. Oh, and All right. Court is calling 2025 CR 001454 State versus Havana Miller. Could I have parties announced?
Lauren Espinoza for the state. Jody Sawyers and Jared Hall for defendant Havana Miller.
And are you Havana Miller?
Yes.
All right, counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovering. Ms. Miller, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
All right. You're charged with cruelty to non-livestock animal as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow that plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Do you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Miller, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're a U.S. citizen, by entering into this plea, you will be deported, not allowed to re-enter the United States, and denied naturalization. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. So we were scheduled for a jury today. There was a jury in the hallway. The court released the jurors after the party said that you all have reached an agreement and are asking the court to accept your agreement. Is that correct, state?
Yes, Your Honor.
Is that correct, defense?
Yes.
So, Ms. Miller, there was a jury in the hallway waiting to come into court. You would have a chance to have the state call their witnesses once the jury was selected. Your attorney would have a chance to cross-examine those witnesses. Did you understand that? And are you giving up that right to a jury trial?
Yes.
All right. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, again, the state is asking that your punishment again be assessed at 10 years in the prison. There's a $2,000 fine. The state is going to be opposed to your application for deferred adjudication. So what that means is they're saying they do not want you to have deferred adjudication. They are in agreement to your being granted community supervision. Do you understand?
Yes.
So what that means, if the court were to deny your application for deferred adjudication, but if the court were to grant your application for community supervision, then the court will have followed your plea bargain agreement. Do you understand? Did you understand that to be the plea? Defense?
That is correct.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yeah, so that's like, I apologize, maybe I missed that in the paragraph, Your Honor. But my understanding, what I explained to her was that any of the motions that we filed and had heard, the motion to quash, the evidentiary motions and stuff like that, those are not being waived because we had a rule and we haven't waived those. Okay, but those have not been waived. Right, so,
All right, so this is what I'm saying. So this is what I need everybody to do. Listen to me closely. Did you sign in both places here, the waiver of appeal paragraph?
yes,
By signing that, this is what it means. You're waiving your right to appeal. The only thing that can be appealed would be any pretrial motions that have been filed, that have been heard by the court and ruled upon. Do you understand?
I do.
All right. Have there been any such motions?
yes.
All right. Now, outside the agreement, the state is requesting that your community supervision be for a term of 10 years. They're asking that there be a TAP evaluation, 150 hours of community service restitution, the MRT, anger management, no pets during probation, field visits, 180-day jail sanction. Do you understand? Those are recommendations from the state, and the court does not have to follow those recommendations. Do you understand?
Yeah.
So those recommendations are not a part of your plea bargain agreement. They're just recommendations. So when you're looking at this plea bargain page, everything above this line, that's your plea bargain agreement. Everything below where it says waiver of appeal paragraph, those are just recommendations.
Okay.
So if the court were to follow your agreement and grant your application for probation, or either grant your application for deferred adjudication, the court is the only person that can give your conditions. So for example, the state is requesting 10 years probation. That's how long they're asking that your probation be for, 10 years. If I don't follow that, if I were to sentence you to 9 years probation, that's not a violation of your condition, because you all are not allowed to reach an agreement for that. They're saying they want 150 hours of community service restitution. If I were to give you 200 hours or 300 hours, that's not a part of your plea bargain agreement. So that's not a violation of the agreement that you've reached. They want the MRT course. If I don't give you an MRT course, that's not a violation of your plea bargain agreement, because that's not a part of your plea bargain agreement. All of these conditions that are below this line, those are recommendations. Do you understand?
Yes, ma'am.
All right. Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor, state offers States Exhibit 1 and all attachments.
No objections.
All right. Did you review the document entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
By entering into this plea bargain agreement, the state is not going to call any witnesses. Through these stipulations, the state is going to present their evidence in the form of police reports, videos, and witnesses' statements. Do you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. If you would like for a PSI and a TAP evaluation, that's 12 weeks. Or if you would like to just reset it and bring witnesses, we can have it brought sooner.
I believe the 12 weeks, if we can do that, to have a full assessment for the court. And then, Your Honor, in regards to, we had already preserved our rights as the constitutionality challenge on a motion of quash
Mhm.
on its face. But at this point, I would also assert to the judge constitutionally as applied. And now that we have the evidence in and the facts, I would like leave of the court to at least file that motion as applied and get a ruling and have a ruling that day.
Follow that motion.
Well, so on a motion to quash, you can't do unconstitutional as applied. You have to wait until the judge.
No, I mean,
or the court-
what motion?
a motion objecting to the constitutionality on as applied. It's timely after there's been an adjudication of guilt. So I just want leave of the court to file that motion and get a ruling on it.
Oh, everybody can file whatever they want to file and I'll hear it.
Fair. I just, because I know right now we're talking about appeal, and I think you'll wait until after the sentencing to do the trial rights certification of appeal. Is that correct? So I just wanted to kind of give the court heads up as to the constitutionality as applied, that we're trying, or our intention is to preserve that. Okay. Thank you so much.
Thank you.
All right.
What date? All right, Ms. Abrams, is there any way to have this expedited before then?
Yes, sir. And I have at least 4 weeks.
All right. What date? In 4 weeks?
Are you asking me or?
Yes, what date?
October 28th.
All right, we'll be back on October 28th for sentencing.
Thank you, Your Honor.
All right, thank you. Once you sign the reset form, you're excused and speak with probation, okay? Thank you. Yes. Well, I mean, it's a PSI and TAP.
Or the video, this is really video.
I'm so sorry. Can I see that again?
Oh, because I'm gonna have to burn another copy. Okay, okay. But I
Oh,
need
there you
the document. Yeah.
Yes, have a great one. All right. All right, you too. All right, anyone else ready?
Report.
All right. Just 1 second. All right, and what is happening with John Thornert? All right, no. No, Thornert. All right, why don't I have a dismissal on the system? Because it's on our docket. Okay, so why is it continuing to appear in the docket? All right, thank you.
Your Honor, may I ask?
Yes.
I just want to see if I can grab the dismissals I left for you.
Oh, those dismissals have already been signed and turned into you guys.
Okay, I didn't.
Yes, no
All
problem.
right, thank you.
Yes, no problem.
No, you have a million ways to sign up there.
Oh, hey, no problem. I try to do it at the same time. All right, who are the two people in the box?
My name's Stacy Smith.
Stacy Smith? I don't see her anywhere on the docket. All right, so where's the cause number? What's the cause number? All right, so when is this evaluation going to be completed? I'll look for it. Hi, if you can come down, Miss Smith. Hello, how are you doing? I'm doing okay. I'm sorry this evaluation is taking so long. Usually the reason why it takes so long is because we have a limited number of doctors to see people, right? So they have told me that they're not going to have a hearing for your competency matter until November 3rd. And here's the problem with that. Once a competency evaluation has been filed, there's nothing that I can do. I can't proceed on it until the other court makes a determination on competency.
Okay, I did speak with a psychiatrist via Zoom last Friday.
All right, so then that means that they're moving things very quickly. So I tell you what I'll do. Norma, if you can email them, because she says she's already spoke with the psychiatrist. And what we'll do is we'll put you back on the docket here and we'll put it for October 20th just to make sure that we still have you and don't lose you, okay?
Okay, okay,
All right, and then
October 20th, what's gonna happen?
on October 20th, it's just for me to make sure that that maybe they have not been able to move faster than what they're telling us.
Okay.
All right. And I don't want you to be sitting at the jail and wondering, have they forgot about me? Okay.
Okay, and do I need to bring these with me, all the class certificates that I've?
Oh, your
completed?
attorney will let me know the classes that you've done and
Okay.
continue to do that and keep up the good work, okay?
Okay,
All right, so we'll bring you back on October 20th, but I'm gonna notate that they are telling me that they won't have that hearing for the competency until November 3rd. But I'll put you on October 20th just in case they have it done sooner, all right?
okay.
All right, thank you so much. And I'm gonna notate here too that you've done classes. What classes have you done?
Anger management, computer, and now another Bible study. And currently I'm doing college prep because I do have a high school diploma.
Oh, wow.
So, and I do have some college, actually, and, what else am I using? Oh, another anger management, yeah.
Okay. And so what I've done is I put that in the system. So if I'm not here, the person will see that you completed those. So if something happens and you lose those records, I already have it here, all right?
Okay, so when am I gonna know what's happening in my life? Not October 20th, not till after November 3rd?
November 3rd at the latest.
Okay,
All right?
thank you.
You're welcome. All right, and who is the other gentleman?
Jacob Rodriguez.
All right, what page is he on? All right, if you'll come down, sir. All right, your attorney arrived late today, and then your attorney is unable to come back. So have you had a chance to speak with your attorney?
Not really.
All right, so what we're gonna do is we're gonna recall this. Normally, this is being recalled for Thursday. And we'll see if your attorney is here, all right? So we'll recall you on Thursday, October 2nd. And Norma, make sure that someone from the MAC is present, please. And then whenever you all are ready, just let me know.